Are you in the middle of a divorce in New York and you have questions about custody? Well, you're in luck because attorney Joseph Marra is here to answer all of your questions.
Now, you also mentioned custody. General rule is you're going to have what's called joint custody. People get kind of upset over that. Joint, I'm not giving him joint. Well, there's joint custody, there's physical custody, and the right of visitation. And I find some people get hung up over joint custody. Physical custody is who has the child most of the time. Not even most of the time, say more than 50% of the time. And the other party has visitation. The main difference with joint custody is the major decisions involving the child's life have to be made jointly. So for example, somebody wants to have a medical procedure or deal with the school and on grades. Well, joint custody kind of have to do it together. As a practical matter, the person who has physical custody is going to have more input, but the other party is supposed to have the input too. And this is another area where there's a lot of consternation and argument between joint custody and sole custody. Sole custody, that parent technically has all the decision-making power and the other parent only has visitation. But generally, to reach an amicable agreement, you try to have it with both parties having joint, one party having physical custody, the other party having visitation rights. I'll tell you a quick story. I had someone come into me once who, a couple had a child, and the child had some pretty significant disabilities that required a lot of day-to-day care. And within a year of the child's birth, the mother found out that the husband was having an affair, and she confronted him and just said he wanted to leave. And this person came into me for a consultation, and she said, I don't think he should have any custody, any visitation rights, anything. He has had nothing to do with our daughter. And she was going on. And I said, look, did he physically, emotionally, or sexually abuse you? No, of course not. Did he physically, emotionally, or sexually abuse the child? No. Well, bottom line is he's going to be entitled to certain visitation, right? Just going to be entitled to it. Whether he exercises it or not is another issue. And to try and fight on that issue, you're throwing money in the street. Where you do have some play here is you have a child with disabilities, and while the child is young and needing this extra care, if he's not able to provide it and is not educated on what the child needs as you do, well, you're going to force him to get that education and to prove that he can care for the child in order to get the visitation rights. That's where you should be focusing on, not on denying him total visitation rights, because assuming the child grows out of the disabilities to a degree and he's able to exercise care of the child, he's going to get his visitation. There's no question about it. Well, this particular person called me back and said, you know what? I decided to go someplace else because, you're not aggressive enough. Okay, fine. 2 years later, I ran into this person at a social event, and she says to me, I should have listened to you. I paid a lot of money for nothing, and that you have happen a lot too. I mean, I should have full custody. You shouldn't see the child for whatever reason. You really have to show that there was some type of abuse in order for that to happen. If you can't, just because the person's not around, they're still going to get the visitation rights, because remember something, the court's primary interest is to do what's in the best interest of the child. Not in your best interest or your soon-to-be ex-spouse's best interest, but the child's best interest. And as a general rule, it's to have both parents involved in the child's life. And that's what the court is going to encourage. So even if the person never exercised their visitation and could care less, if you're in a divorce and they have a decent attorney, the attorney's going to say, hey, look, let's give you these rights. You don't have to exercise them. Fine. That's not a place for argument. Agree to it. And unless, as I said, the person has been known to physically, mentally, emotionally abuse the child. I've had one person say, well, you know what he does? He says he's going to be with my daughter, and he picks her up and dumps him with her mother, and then the child doesn't see her after weekend, see him after weekend anyway. Well, do you really know that? Number one. And number two, let's assume that's 100% accurate. Is a court going to deny him visitation for that? Probably not. I mean, the child is being cared for. The child is spending time with family. The child is seeing the father during that time. The child, it's not something to fight over. And you have to pick your battles in divorce because battles are very expensive. And they better be righteous battles, not vindictive battles or not emotional battles. It is the type of thing, custody and visitation. You set those things early on, either it be in an initial agreement while the divorce is pending, and then it is finalized in your divorce decree and or your stipulation of settlement. But it can change, and circumstances change, and one party can always go back to court.
Thank you so much, Joe, for that important information, and thank you, audience, for watching. If you yourself or someone you know may have questions on this topic, please don't hesitate to pick up the phone and call the law offices of Joseph Marra. They are professional, friendly, and really great at looking at the pros and cons of your situation, coming up with a fantastic strategy, and giving you some options.